Let's talk about what Bryan Kohberger's defense is planning right now for a strategy or what moves they're making in the court of law. So, as many of you know, Kohberger was indicted by a secret grand jury impaneled by the state on May 16, 2023, on 4 counts of first-degree murder and a single count of burglary. Since that time, the state and the defense have been going back and forth over what grand jury materials will be made available to Kohberger's defense team. The state has offered audio recordings and partial transcripts of the grand jury for review. However, Kohberger's defense argues that they are certain evidence exists that would clear him of these charges, exculpatory evidence. And according to court documents, they are requesting the court to force the state to turn over all grand jury proceedings for review. So Kohberger's defense is arguing that after 6 months of intense media coverage in the small community, they have a right to determine how the grand jury was selected and what, if any, exculpatory evidence was shown to the grand jury. The defense also argues that since the case carries the potential of the death penalty and that Kohberger has not waived his right to a speedy trial, the state's failure to provide all requested materials will slow down their ability to make a robust defense for their client, Bryan Kohberger. In a motion that was filed with the court, defense counsel Ann Taylor requested that if all such documents and materials are not turned over without delay, that the court should put a stay or pause on the proceedings and allow adequate time for review of the grand jury proceedings. Now remember, the state has already turned over 51 terabytes of discovery to the defense. The state's response in court documents shows that Bill Thompson, who is the prosecuting attorney, agrees that the discovery in this case is substantial and that a major trial is set to take place in under 4 months. Oh my gosh. Thompson's response says that he does not have any problem with a reasonable extension of time for the defense to comply with its obligations under Idaho law. However, he requests the same courtesy for the state should the defense proffer a notice of alibi. The back and forth between the two sides continues, as is expected in the case of this magnitude. So the question here in these recent court filings is one of each side learning more information about the game plan of the other side. So of course, the defense wants to know more about what happened at those grand jury proceedings because that is going to give them a lot of information regarding what exactly the prosecution knows. And of course, the prosecution is wondering, probably like all the rest of us are, what the heck is the defense talking about with this exculpatory evidence? Because until they put some evidence forth, exculpatory evidence is just 2 words and it really means nothing more. What that exculpatory evidence could be is, a figment of probably your wildest imagination because we don't know a whole lot of facts about this case to begin with. And of course, the prosecution wants to know what Bryan Kohberger's defense is going to put forth as his alibi so they can start to focus on the elements of that alibi so they can begin to attack the elements of that alibi, therefore showing that his alibi is false, fictional, made up, not real, and what their ultimate goal is to show that he is guilty of the charges that are before him, the 4 counts of homicide and the count of burglary. So the notice of hearing states that Bryan C. Kohberger, through his attorney Ann Taylor, the public defender, will call for hearing the defendant's motion to stay proceedings on June 27th, 2023. So that's possibly going to be the next court proceedings when the judge is going to hear the oral arguments from the defense for the motion to stay. If they are not granted the motion to have the information from the grand jury proceedings disclosed. The second court filing with the date of June 14th, 2023 is a temporary order in response to the motion to seal certain evidence. So this is what the order says. Based on the motion of the state filed herein, the court does hereby confirm and order that the motion to amend order allowing removal of evidentiary items for forensic evaluation and amended order allowing removal of evidentiary items for forensic evaluation are exempt from disclosure and are sealed pursuant to Idaho Court Administrative Rule 32G1 for the reasons stated in the said motion and until a hearing can be held on the matter. So this right now is just ensuring more secrecy between the prosecution and the defense and what they have to support their positions, and also more secrecy about what is going on in the pre-trial proceedings for this case, as has been the case ever since Bryan Kohberger was arrested. So what is coming next? We will only be able to know that when it happens, as has happened with everything else in this case. Stay tuned, and thanks for watching.